The day started like any other on my ranch. Then I noticed a certified letter stuck under my windshield wiper. I expected a tax notice or maybe county paperwork. Instead, it was a lawsuit from the HOA next door. At first, I thought it had to be a mistake. I had never lived inside their subdivision. I wasn't even a member of their HOA. Yet somehow, they claimed ownership rights over part of my land. The subdivision sat on land bordering my ranch. Most residents were wealthy retirees and vacation homeowners. They loved the mountain views. What they didn't realize was who actually controlled their access road. The HOA president was Melissa Carter. She believed money and lawyers could solve every problem. After a few new developments were approved, she decided my ranch land was standing in her way. The lawsuit claimed that part of my property belonged to the HOA. Their argument was complicated, but the goal was simple. They wanted control over land connected to their only entrance road. I immediately hired an attorney. Within an hour, he started smiling. That was the first sign something wasn't adding up. The HOA had overlooked one very important detail. The access road crossed my property through an old easement agreement. The document was decades old. Most people had forgotten it existed, but legally, it still mattered. I owned more than 1,600 acres. Every boundary had been surveyed and recorded. I knew exactly what belonged to me, and I knew exactly what didn't belong to the HOA. Meanwhile, the HOA became more aggressive. They seemed convinced the court would side with them. Their lawyer filed motion after motion. Each one demanded more control over my property. That was the moment I stopped worrying. If they wanted to fight, they would get one. But I planned to let the facts do the talking. And the facts were on my side. Over the next few weeks, we gathered every document we could find. Property records, easement agreements, and county filings. Some of the papers dated back more than 40 years. Every page strengthened my case. The breakthrough came inside the county records office. Buried in old archives was the original easement agreement. Most people would have overlooked it. For us, it changed everything. The document clearly described the access arrangement. The HOA could use the road, but ownership of the land never transferred. That distinction will become critical in court. Instead of backing down, the HOA doubled down. Legal bills started piling up. Some residents began asking questions. But Melissa insisted victory was guaranteed. Not everyone shared her confidence. Several homeowners were worried about the costs. The lawsuit was draining association funds. Yet the board kept pushing forward. Meanwhile, life on the ranch continued. I checked fences and livestock every day. The road crossed only a small portion of my land, but it was the subdivision's only practical entrance. We hired independent surveyors. Their job was simple: confirm every property line using modern measurements. The results matched my records exactly. The new survey removed any remaining doubt. Every boundary was where it was supposed to be. The HOA's claims didn't match reality. And now we had expert testimony to prove it. For the first time, cracks started appearing. The HOA's attorney looked less confident. The evidence wasn't supporting their arguments. And everyone in the room knew it. The first major hearing finally arrived. Both sides entered the courthouse that morning. Months of preparation had led to this moment. Now the facts would face a judge. The HOA argued that controlling the land was necessary. Their attorney spoke for nearly an hour. Then our side presented the actual records. The atmosphere in the courtroom changed immediately. When the judge reviewed the original easement agreement, he asked several questions the HOA struggled to answer. For the first time, Melissa looked genuinely worried. The case was starting to move in an unexpected direction. At the second hearing, our attorney revealed a section nobody had discussed before. It wasn't hidden. It had simply been ignored for decades. And that oversight was about to become a major problem for the HOA. The clause was straightforward. The easement granted access, not ownership. More importantly, it could be terminated under specific conditions. Conditions the HOA had unknowingly violated. The moment the clause was mentioned, the HOA attorney's expression changed. He immediately began reviewing his notes. Even he seemed surprised by what he was reading. The judge requested additional documentation. Nobody objected. The courtroom had become unusually quiet. Everyone understood the importance of the discovery. Outside the courthouse, my attorney smiled again. He said the case had just taken a dramatic turn. For months, the HOA had been attacking my position. Now they were defending their own. That evening, the HOA board held an emergency meeting. Word of the hearing spread quickly. Some members wanted to settle immediately. Others insisted they keep fighting. Residents started asking difficult questions. Many had purchased homes assuming the road issue was settled. Now they were hearing rumors that access rights could be affected. Concern began spreading throughout the community. The court ordered independent experts to review the documents. Their task was to verify the history of the easement. Neither side could influence their conclusions. The facts would speak for themselves. When the expert testimony arrived, it confirmed everything we had argued. The easement belonged exactly where the records showed, and the HOA's ownership claims had no supporting evidence. By the end of the day, the momentum had completely shifted. The HOA no longer looked confident. Their attorney seemed increasingly concerned, and the trial was far from over.